this release that is going to be coming out later today, which is pure election interference, lawfare at its worst.
That's right, Jordan. If you'll remember, we talked about on the broadcast just a little over a week ago that the judge released the brief that Jack Smith had filed with some redactions, but unsealed this evidentiary brief that Jack Smith had filed, trying to get ahead of the November 5th election. But now Judge Chutkan has ordered that today the appendices, the documents, the records, all of the primary documents, if you will, of the evidence that went into that brief shall be made public today.
Remember, he had to go and refile before a new grand jury after that Supreme Court case that gutted most of Jack Smith's initial case, trying to involve President Trump and say he was part of a conspiracy to lead this overthrow of the U.S. government and the riots, and that he's responsible because he gave a speech and told people to behave and told people not to do and take these kind of actions. But he filed again, and we saw that filing released a couple weeks ago with the kind of new charges. And basically we worked through it and said, two of those four charges the Supreme Court has already thrown out. So really, Jack Smith, again, this is a political hit job. And now we have, on a Friday drop, more evidence that was attached to, this was in the appendix that Jack Smith filed, that he's asked for the court to release with minimal redactions. The only reason to do this is to interfere with the elections. And Judge Chutkan trying to say that if she didn't release this, it would interfere with the elections is the exact opposite role of why we have these court systems and how these court systems must be regulated.
If you go back to someone who we don't normally quote too much for positive purposes, but actually he is pretty intellectually honest when it comes to legal analysis, it's Elie Honig from CNN. He's the one who wrote in New York Magazine that this is Jack Smith's October cheap shot. And he goes on to say that the conduct here by Jack Smith violates core DOJ principle and policy with the way he asked the judge to do the order of this, with the brief, with getting the evidence out. So even the fact that left of center legal commentators who are calling it as a straight shooter here, that Judge Chutkan should be able to see through this.
Essentially, Judge Chutkan has got her logic and her legal analysis exactly backward. So she decides to release these allegations in order, in my opinion, to interfere in the election. But then she claims that Trump's efforts to block this information before the election is an attempt to interfere. So she must release it according to her strained logic. Keep in mind that the judge in the election interference case, Judge Chutkan, is releasing additional unredacted appendices days before the election. But we should note that no proven evidence is being released, only allegations are being released. We are only seeing one side of the equation. And the purpose of this release is to damage Trump's campaign, which is precisely why Trump and his legal team opposed it.
The judge here is trying to argue that this should be publicly available information, that the public is entitled to evidence in a trial. And while that may be true, what is so glaring here is the way that things are being done out of order. Typically, yes, that evidence is presented at trial, and that evidence would be public in a trial setting, except for maybe in some very rare circumstances. But this isn't at the trial phase yet. There's no jury that has been called. This is preliminary evidentiary hearings that have resulted in publicly released information. You typically think about things like discovery and evidence where the defense and the prosecution are privy to what's going on, but it seems completely out of order that they're saying, let's just post it all online before the election. I want to get your thoughts on that.
Yeah, I think that this is, again, it's ultimate lawfare. at its worst. These judges who have any potential to do any damage to President Trump, even though they had to toss out the initial case that Jack Smith brought against President Trump because the Supreme Court clearly said most of what you're trying to charge here, you can't do because the president is protected when he acts officially. And you're going to have to go through every one of these little pieces of evidence and argue in court how, if you're a prosecutor, that wasn't an official act while he was president of the United States and how that was somehow unofficial. And how are you going to draw that line? So the fact is, like Harry said, a lot of this evidence could ultimately be tossed out of court because they have to play this very interesting and unique style of prosecution if they do move forward with this, which, let me tell you, if President Trump wins the election, this case will go nowhere further. So what they're looking to do now is say, well, we may never get a trial on this, so let's do every piece of damage we could possibly do to President Trump before and as people are casting their votes today. I mean, we're 18 days out from Election Day, but we're getting in, probably by Election Day, nearly half the country will have already voted. And they will have this kind of information without a full, again, we know it's coming out today, without a full response from the Trump team. The judiciary is not supposed to make decisions that could sway people one way or the other because they already had to decide that they couldn't move forward with the trial. They've already had to refile charges because of the Supreme Court case. So this case, it wasn't going to be heard for a very long time. So many motions coming. But yet, will they figure out a way to try and get anything possible in that appendix? And the only reason I think Jack Smith could possibly want this out is that this is his final shot. He knows that he is not going to be able to move forward with this case anytime soon, and especially if President Trump wins. So this is his final opportunity to try and damage the president of the former president of the United States just 18 days out. And we have got to stand up and realize that he must think, Will, that usually these appendixes wouldn't be so much different than what he was already released with some redactions. There must be something in there that he thinks is important enough to try and, as he did, convince a judge that she's not interfering with the election by releasing it. There's something fishy here that we are going to have to be on the lookout for.
And to some degree, he also may know that the media will do his bidding by writing stories, by laying it out, coming up with their own conclusions based off the evidence, and do a lot of his job for him. And I want to read this quote one more time from Judge Chutkan. If the court withheld information that the public otherwise had a right to access solely because of the potential political consequences of releasing it, withholding it could itself constitute or appear to be election interference. It sounds like she's telling the American people, you're the jury now. You get to decide if he's guilty or not in this case. And that's actually not how the American legal system works, where you are innocent until proven guilty by a jury of your peers.